Welcome back to the OMB Law Board. Today I've got Harley Wilkinson, a Senior Associate with the OMB Estates team. Welcome back, Harley.
Good to be back, Simon. Thank you.
Harley, in a previous episode, we've talked about the importance of the will and being appointed an executor, etc., under a will. But it's not always just the will that matters and gives force to the wishes of the deceased party. Sometimes we need to go a little bit further.
That's exactly right. Sometimes it's going to be necessary for an executor appointed by will to go off to the Supreme Court and obtain what we call a grant of probate.
Excellent. So if you're interested in understanding the importance of not only a will, but when a grant of probate is required and what in fact it is, stick with us today as we drill down on all things estates and grants of probate in wills. So, Harley, let's get into a little bit. I need to understand, what is a grant of probate?
Fundamentally, it's an order that's made by the Supreme Court.
Okay. But I've got a will,
Yes.
and the will tells me the deceased's wishes.
Yes.
And says, I would like to leave these things, et cetera, and sets them out clearly.
Mm-hmm.
Why isn't that enough?
The way you've described it is exactly right. That's everything a will is doing. But sometimes we need to go a little bit further in terms of proving the validity of the will. That's really what probate is all about. It's often going to be described as proving the will. So by applying to the court, obtaining a grant of probate, it's really the best evidence that an executor can obtain to say or to show to third parties that they have authority to deal with assets and act on behalf of the estate. And sometimes it's a grant of probate that third parties like banks or the titles office or super funds will require that an executor obtain before they're going to be prepared to deal with the executor at all or release assets to the estate.
So the will itself won't be sufficient to deal with some of these parties. Is that correct?
Not always, no.
Right. And they will require that executor goes off and seeks this approval of the court.
Yes.
Which validates the will.
Yes. It essentially confirms their appointment as executor. It means that they have authority to deal with the estate assets. So it gives third parties confidence and certainty that they're dealing with the appropriate person who has authority to be transacting on behalf of the estate.
And can you tell us, does it also give the executor some form of protection by the court order?
It does. Yes, it does. And that's a really, really important thing to point out, is that a grant of probate does give protection to an executor who's obtained a grant. So I'll use a bit of an example here. So let's say that there is a bit of doubt about what will is the last will a person left behind. If you've got a will from 20, 30, 40 years ago, not too sure if there was one that was done more recently, and we have an executor in that old will who's applied for a grant of probate, they've taken some steps to administer the estate, perhaps they've closed some bank accounts or sold a car, it later comes out that there's a much more recent will, 3 or 4 years ago. Having applied for and obtained that grant of probate on the older will, that executor named in the older will is protected by virtue of having taken out the grant for the steps that they've taken to sell the car, close those bank accounts. It means that they're not at risk personally.
But they would or potentially could be otherwise had they not taken out this grant of probate.
That's exactly right. Yeah. So a lot of the time, whether or not a grant of probate is required will hinge on what the assets of the estate are and how much they're worth, what the value is. So if we've got quite a lot of money sitting across bank accounts, there's superannuation, life insurance, investments or managed funds, often executors have to get probate anyway in order to deal with those, in order to have those assets released. But it can be desirable in some cases for executors to apply for a grant and obtain one anyway, even if it's not strictly speaking required.
So even if you don't need it, you can still elect to get it as a form of protection?
Yes.
Okay.
Yes.
So let's take a step back. Tell us, what's a process for you to obtain a grant of probate on a will for someone?
So we will normally have to meet with executors. We'll have to have a look through the will, the death certificate. It's really important that we inspect and scrutinize the will to check for any abnormalities or anything unusual about its making or the circumstances surrounding its making, because that's exactly what the court is going to do. So we've got to prepare the application. We've got to prepare a supporting affidavit, a whole bunch of other supporting material. We've got to advertise the executor's intention to apply for a grant. So that basically notifies any other interested parties or creditors or anyone who might hold a later will.
So that's a really important step.
It is indeed. It's a requirement.
So it's a notice to the world. We're going to seek the court to approve this will. If you have knowledge of a more up-to-date will
Yes.
or another claim that overrides this, you should come forth now.
Exactly. So using that example I mentioned earlier, if we are applying for a grant on quite an old will and there's some doubt about whether or not there is a more recent one, that advertising process is a good way to flush out later wills. So if there is a later one, it's going to be up to whoever it is that's holding that will or whoever it is that wants to prove that more recent will to come forward and bring it to the attention of the executor.
Okay. So I need to get a better understanding of when I need a grant of probate and when I don't. So I'm going to quickly fire a couple of scenarios at you. Can you let me know, do I need a grant of probate or not?
Yes, I can.
Small estate, small amount of cash in the bank, that's it.
Probably not, no.
Small estate, selling cars?
Usually no, although it can depend on the value of the cars and what the requirements are for the transport department.
Medium estate, involving real property, houses, units, etc.
If it's in Queensland and there's more than one property, then yes, grant of probate will be required.
Substantial estate with substantial money in bank accounts?
Yes.
Medium
Absolutely.
to substantial account with reasonably large shareholdings?
Yes.
Starting to get the hang of it, but as you said, it can be at the executor's election whether
Yes.
they want to get it anyhow or not.
That's right sometimes. And that's going to be in the case of estates where there aren't a great deal of assets, or maybe there's a lot, but the value of those assets isn't such that the asset holder or that third party actually requires the executor to take out a grant. You know, using as an example, if we had a will maker who passed away, they did all their banking with CBA. CBA is a bank that has a threshold limit of $100,000. So if you've got funds across all your different accounts with CBA that exceed $100,000, the bank is going to require that the executor apply for probate, prove the will before the bank releases the money to the estate.
Okay, so how long does this process take?
It's one of those it depends answers. Typically, it'll be anywhere from 2 to 3 months if it's a standard probate application. It can take a little bit longer depending on whether or not there are any issues in relation to the will. If there are questions around whether or not it's valid, if it's been signed or witnessed properly, if it looks like it's been tampered with or made under suspicious circumstances. Otherwise, if there's some information or evidence there to suggest that the will maker didn't have capacity, sometimes there's going to be a little bit more that needs to go in, and that can drag it out. That can cause delays. At the same time, if when you put in your application first, you're missing some information, the court can also requisition that application, and they can say that we've got some things we're missing. We need you to address 1, 2, 3, 4, or we need you to provide some additional evidence before you can get over the line.
Yeah.
And that's something that can extend that period. But typically, standard probate application, 2 to 3 months at the moment.
So if you're an executor under a will, or if you have concern about the validity of a will, or if you've got a will with substantial or medium assets, it's likely you're going to need a grant of probate. You need to seek advice early, I guess, Harley?
Yes, absolutely. Yeah. Yeah. So, because what can happen is if you're an executor and you're taking steps in an estate administration, you might want to avoid the time and expense of going and applying for a grant of probate. If there's real property, for instance, you can actually deal with that independently of obtaining a grant. If you go ahead on that basis, we typically have to give up the original will to the titles office. If you later find out that you need a grant of probate to administer some other assets, that means we're going to have to retrieve the original will from the titles office. It's going to create all sorts of delays. But going in and getting that advice early, you're going to be alerted to those risks and whether or not you might need to obtain a grant in relation to particular assets or not. So getting advice early on is going to be a good way to protect against those delays and additional costs you could incur as a result of not having gotten that advice.
And that advice is available with our OMB estates team.
Mm-hmm.
And for those listening and watching in, if you do have questions, please contact our estates team for any queries or drop us a note below. And thanks for tuning in on this episode of the OMB Law Board. Thank you, Harley.